Hey guys, how's it going? So it certainly appears that the ATF has now decided that pistol braces, yet again, when attached to a pistol, would constitute a short-barreled rifle, and if it's not registered, could be considered a felony. Now look, there's no legal advice in this video whatsoever, and I want to say right off the bat here, I'm not suggesting anybody get rid of your pistol brace right now. Consult your own lawyer if you need legal advice, but if you've been following this channel, you know that the pistol brace rule that was set to affect tens of millions of people in the United States has been battled in court. We've covered that extensively on this channel, particularly over a year ago now. And there were several courts. One court, district court in Texas, I believe, vacated the whole pistol brace rule and said there isn't one in the whole country. Another court, and I believe this was in the GOA case, GOA's been litigating so much lately, shout out to them by the way, that said that all of their members were enjoined. There was an injunction, and we're going to get into more details about that in a little bit. And I'm going to say this, in my opinion, the ATF is probably in contempt of court right now, completely and utterly ignoring federal court decisions regarding their pistol brace rule. But yeah, it appears right now the ATF is yet again, apparently, even though we were supposed to have had this settled a while ago, that as of right now, pending different appeals, things like that, that the pistol brace was generally good to go. State laws may vary, but certainly on the federal level. So I was talking to one of my friends at GOA earlier today, and he shared this letter with me. And it's been snowing all day today, and I do snow removal for a living, so I've been out busy with that, but I was able to sneak back into the shop here to share this with all of you. Now, this is a letter that Eric Pratt of Gun Owners of America wrote to Megan Bennett. She's the Assistant Director, Office of Enforcement Programs and Services with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Now, let me say this before we even read this letter. I'm going to get into this. First of all gun control, completely and utterly unconstitutional. The fact that the National Firearms Act even exists is completely abhorrent and affront to the Second Amendment, which very clearly states, shall not be infringed. So I don't personally accept the premises of any of this, and I believe the Second Amendment is the supreme law of the land, as is the United States Constitution. But as I always say, yet here we are. And the ATF may be trying to come after people's pistol braces again. I don't know if they're coming after people actively, but it certainly appears that they believe that they're still short-barreled rifles, besides courts telling them, no, your ruling was unconstitutional. It violated the Administrative Procedures Act and all of this. So that's the skinny of it for all of you who only have 2 minutes. I'm going to read through most of this letter here, and if you would like to see this whole letter, I'm going to upload the PDF of it to my locals community. The link for that is down in the description because there's a feature there where I can upload a whole PDF, and you should be following me on locals anyways because I post extra content there. It's censorship free, and I usually do a weekly bonus live stream as well. So this is kind of crazy. I want to go through this because this just shows you how corrupt the ATF and our bureaucracy is truly become. So this is regarding recent FIPB, which is a certain division of the ATF. There's so many acronyms, it's hard to even pronounce any of these names, but we're going to go through this. Pistol brace guidance to Gun Owners of America member violates Southern District of Texas court order. Dear Ms. Bennett, my name is Eric Pratt. I am the Senior Vice President of Gun Owners of America, Inc., GOA. The Senior Vice President of Gun Owners Foundation, GOF. GOA and GOF are nonprofit corporations dedicated, inter alia, to preserving and defending the Second Amendment rights of gun owners. GOA and GOF together have more than 2 million members and supporters nationwide, including me and most of my family as well. As you know, ATF issued a final rule in early 2023 entitled Factoring Criteria for Firearms with Attached Stabilizing Braces. 88 Fed Reg 6478, the rule, which purported to clarify when a pistol equipped with a stabilizing brace is in fact a short-barreled rifle, SBR, subject to taxation, registration, remember that, registration, that's what the NFA is, it's a registry, and attendant criminal penalties under the National Firearms Act, NFA 26 USC 5801. This rule was slated to affect millions of commonly owned firearms, claiming them to be unregistered SBRs, possessed in violation of the NFA. Yet the rule offered no clear guidance as to when ATF would consider a brace pistol to be an unregistered SBR. Now look, I'm going to stop and give my commentary on this from time to time. There were actually a couple different rules. The one had this checklist and point sheet that you had to go through, and it was so convoluted that the more you searched for the answer, the more questions you had. We covered that on the channel when it was going on. Then they came back with another rule where it was still about as clear as mud, and there might have been maybe technically in theory a couple brace pistol options that would not have been considered SBRs under the rule. You still had no idea what you were doing, and the whole thing was completely insane, and we'll keep going to talk about that here. Instead, the rule merely referenced the stabilizing brace's surface area and then identified 6 factors ATF would consider behind closed doors in making individual determinations. Even so, the rule emphasized that it only served to clarify that certain weapons equipped with stabilizing braces are short-barreled rifles regulated under the NFA. Not that every weapon equipped with a stabilizing brace would be an SBR. GOA and GOF sued ATF and the U.S. District Court for the Southern District of Texas to enjoin the rule, explaining that the rule violates the Administrative Procedures Act and the Second Amendment, among other provisions of law. On October 27, 2023, the Southern District of Texas preliminarily enjoined the rule as to the individual plaintiff and his resident family members, as well as GOA current members and their resident family members. And we reported that on this channel too. And it goes through citing the case, Texas v. BATFE. This injunction remains in effect during the pendency of ATF's appeal to the Fifth Circuit. Other district courts have similarly enjoined or vacated the rule, and the U.S. Courts of Appeals for the Fifth and Eighth Circuits have rejected the rule as well. And then he cites all the different cases, and there's literally like a whole list of them who have rejected this ATF rule. One would think that ATF, a federal law enforcement agency, would abide by the district court's injunction not to enforce the rule, not to mention the similar injunctions and one vacatur entered by other federal courts. Unfortunately, one would be wrong. On December 12th, 2024, a member of Gun Owners of America received a response to a question posed to ATF, signed by an identifiable ATF official. Signed not by any identifiable ATF official, but rather generally FIPB, standing for ATF's Firearm Industry Programs Branch, attached with personal information redacted. In this December 12th, 2024 email, FIPB adopted a legal position about pistol braces that is, at odds with the opinions of various courts to have considered the rule. 2. Likely in violation of various injunctions against ATF's enforcement of the rule. And 3. In conflict with the statute and even the final rule itself. So the ATF now, according to this letter that they sent an individual, is now saying that their interpretation of pistol braces is even actually worse than the rule itself. This is literally crazy. Just think about this. Specifically, our member reported having, quote, recently purchased a CZ Scorpion Mini Plus pistol and considering installing a pistol brace. However, having encountered conflicting information regarding whether this modification would require the firearm to be registered as an SBR, the member asked for clarification on the applicable regulations. In its response to that report, FIPB responded with the position that federal law requires a pistol with an attached stabilizing brace or stock to be registered as a short-barreled rifle. Yeah, this is insane. FIPB's email contains no qualification on that broad statement. In fact, ATF has no idea what sort of brace this GOA member planned to install on the pistol. In other words, FIPB advised this GOA member that if a pistol is equipped with a stabilizing brace, then it is an SBR, as a categorical matter, irrespective of the multiple court's orders that ATF not enforce that reasoning, and even despite the rule's factorial test and ATF's assurance that only certain weapons equipped with stabilizing braces would be SBRs under that test. And this is the rule. 88 Fed Reg 6554, emphasis added. FIPB continued, despite acknowledging an injunction issued by the Northern District of Texas against the rule. FIPB then posted that, irrespective of injunctions against the enforcement of the rule, quote, ATF remains responsible for enforcement of statutory provisions. Wow, under the NFA. Opining that ATF may enforce its new view of the law, the rule, and enjoining it notwithstanding. In other words, it would thus seem that FIPB now considers all brace pistols to be SBRs, an alarming change in position which was not announced publicly or in any representation to any court, but rather in a private communication to one GOA member. So that tells us we don't even know the rules and what the ATF believes the law is technically, because they're not even telling courts or the public at large. It's just kind of like they know the rules, we don't. There's this common saying the younger kids use. I believe the acronym is FAFO. And they want you, in my opinion, to be too afraid to do anything because you don't know what the current rules are. Let me know what you think about that down in the comments. Of course, FIPB's entirely new position goes much further than even the highest contested final rule, which opined that nearly every, but not every, pistol with a stabilizing brace would be an SBR. See Mock 2024 U.S. District. Lexus 105230 at 11-12. Under the final rule, the ATF estimated about 99% of pistols with stabilizing braces would be classified as NFA items, and that's the frack lawsuit. By the ATF's own estimation, 99% of brace weapons are rifles under the NFA and GCA, not just a simple majority. But, as noted, both the 8th Circuit and 5th Circuit have flatly rejected this result. See Frack and see Mock. These are previous cases that we were talking about earlier in the letter. And in addition to being even more expansive than the rule itself, FIPB's new position likely violates the Southern District of Texas's order that ATF's expansion of NFA liability not extended to members of GOA. Ignoring the district court's order in our case, FIPB's email adopts the cutesy theory that even though ATF has been enjoined from enforcing the rule, it may still enforce its interpretation of the statute. That's, wow. Which, not coincidentally, just so happens to be identical to, if not worse than, the interpretation laid out in the rule. See attachment. ATF is complying with the court's order, but the district court's order does not prohibit enforcement of the NFA or GCA, only action in reliance to the final rule. I'd like to see a federal judge be like, fine then, you want to be cute? You want to try to go in circles and make everybody afraid to own a pistol? How about we just say we won't enforce the NFA or GCA at all? I'm serious. This would be a good opportunity for a court that actually appreciates and follows the Constitution just to say, fine then, all of it's unconstitutional. What do you think? Not only is this spurious theory too cute by half, but also is likely violates the orders of the numerous courts which have expressly stated that ATF may not enforce the legal theories advanced in the rule. For ATF to claim to enforce those same theories under the statute, but not under the rule, is a distinction without a difference. Yeah, and I would note, requires the listener to be dumber than the speaker. And one that demonstrates FIPB's contempt for these federal courts and the rule of law. See, before I even read this letter, I said, in my opinion, I believe the ATF's probably in contempt of court right now. Even worse, the FIPB's purported blanket ban on pistols with stabilizing braces during litigation over the rule. ATF previously asserted, without explanation, that the specific firearm at issue here, a CZ Scorpion Mini, with a stabilizing brace attached was an SBR, but had that conclusion rejected by the U.S. Court of Appeals for the 8th Circuit. See the Frat case. And the ATF judged the picture weapon to be a short-barreled rifle, but the slideshows are devoid of any explanation as how the ATF applied the final rule to the pictured weapons. That indeed, the brace rule allows the ATF to arrive at whatever conclusion it wishes without adequately explaining the standard on which its decision is based. See also ID at 524. The final rule makes it, quote, nigh impossible for a regular citizen to determine what constitutes a brace pistol and whether a specified brace pistol requires NFA registration. And again, this is stuff from that court case, right? And he's citing all of the sources down here. In other words, ATF's theory specifically applied to the CZ Scorpion pistol at issue here was rejected as applied to a firearm equipped with a PDW stabilizing brace. And yet, FIPB's email takes the position that the very same firearm, when equipped with any stabilizing brace, is a short-barreled rifle. The audacity of that claim, which directly conflicts with the decisions of 2 federal courts, cannot be understated. What is more, as GOA explained to the court in its pistol brace case, numerous prior ATF classification letters have determined that a stabilizing brace, when added generally to any pistol, does not turn the firearm into a short-barreled rifle under the NFA. GOA complaint, supranote, and then it goes through and cites, and although the final rule purported to rescind all of these previous braced weapon classifications, declaring them no longer valid, that rescission was enjoined and then later vacated. Going back to Mock v. Garland. Now there's more citing of some cases here. Okay. That means that ATF's prior braced weapon classifications are back in effect, never having been lawfully rescinded. See? So the previous letters that said braces were good to go, according to Mr. Pratt of the GOA, he's saying, look, you said you rescinded all those letters, but your rule was considered to be unconstitutional, right? So they have not been rescinded. So this means the ATF's prior based weapon classifications are back in effect, never having been lawfully rescinded. This includes ATF's repeated determination that certain braces can be placed on any pistol without running afoul of the NFA. And again, one of those classification letters involved a brace used on the CZ Scorpion, the very firearm about which our member inquired. GOA Complaint 67, FIBP's email to our member does not purport to rescind ATF's prior classification letter approving the use of a brace on such pistol. Almost done here, but this is good. We are not aware that ATF has promulgated any subsequent rulemaking where it is now possible, quote, for a regular citizen to determine what constitutes a braced pistol, and that's the Frat case, versus a short-barreled rifle, nor are we aware of any new ATF classification letter as pertaining to stabilizing braces vis-a-vis the CZ Scorpion Mini. Thus, FIPB is doing precisely what it was enjoined from doing, making ad hoc determinations in secret based on vague and unpublished criteria that no ordinary person could hope to understand. Of course, a designation by an unnamed official using unspecified criteria that is put in a desk drawer, taken out only for use at a criminal trial, and immune from any evaluation by the judiciary, is a sort of tactic usually associated with totalitarian regimes. And it cites United States versus Pullingan, which is another 7th Circuit case from 2009. So there's already case precedent based on this. A final point bears emphasis. It is difficult to imagine FIPB's novel interpretation of the NFA and unprecedented attempt to circumvent the orders of several federal district courts surviving the eminent turnover in presidential administrations and forthcoming confirmation of the new ATF director. To the contrary, lawless actions like these stand out like a sore thumb for those like GOA who seek to stamp our government weaponization and corruption wherever it exists. GOA previously submitted its concerns via an email request to Acting Chief Matthew Scheer and Chief William Ryan. this Monday, January 6, 2025, outlining GOA's concerns with FIPB's interpretations. And he puts this in bold and underline this next part. We requested an answer by close of business yesterday, Wednesday, January 8th, 2025. No response was received, and thus it appears that both Chief Ryan and Acting Chief Scheer stand behind the unlawful position in the December 12th email to our member. Thus, we are now elevating our concerns to you. Accordingly, we demand your immediate clarification that the FIPB email sent to our members does not, in fact, represent ATF's official position on the issue, but rather was issued in error. So they're going to ask them to clarify, was this just a mistake? Or did you really mean this? To the contrary, we demand your strong assurances that it is your understanding that the mere fact that, that a pistol is equipped with a stabilizing brace does not dispositively render it a short-barreled rifle. Finally, we demand your guarantee that ATF intends to comply with the district court orders enjoining enforcement of the rule. This compliance includes refraining from enforcement of the rule's flawed and repudiated theories repackaged in an injunction sidestepping statutory theory or any other theory which purports to comply with the injunctions but nonetheless exposes GOA members to criminal liability. Rather, it is our understanding that, pending resolution of existing litigation, ATF is, or should be, awaiting further guidance and not taking any definitive positions on issuing classifications with respect to the status of pistols equipped with stabilizing braces. Please let us know if this understanding is not correct. Please send your response to us in writing within 3 business days of the date of this letter or by the close of business on January 14th. We remind you the FIPB email to our member was signed FIPB, a branch you direct under the Office of Enforcement Programs and Services. Thus, if we do not receive your response within 3 business days, we will safely assume that the flawed positions articulated in the December 12th email to our members are properly attributed to you, and in that case, we will proceed accordingly. We suggest that you consider this letter carefully, and we look forward to your prompt reply. Sincerely yours, Eric Pratt. Let me know what you guys think. This video went a little long, but I thought this was an excellent letter, and I did want to read all of it. And if you want to read it all yourself and some of the court citations that I did skip here, because, you know, the video went long enough, and I wanted it to be as brief as I could, make sure you check out my locals community, and I'm going to make a post right now before you see this video where you can go in and look at the whole letter yourself. All right, more Michigan stuff coming up soon and other national issues, and yeah, it just never ever stops, does it? All right, thanks for watching, and have a good one.